U.S. lawmakers challenging the definition of a broker in U.S. President Joe Biden's infrastructure bill that was signed into law in November. Representatives proposed following a definition which avoids placing unworkable customer reporting obligations on parties who do not, in fact, have customers, such as crypto miners and stakers. But also tucked away in that bill is another hidden crypto provision that amends part of the tax code in a way that my next guest believes will greatly expand financial surveillance, criminalize certain cryptocurrency transactions, and violate the Fourth Amendment of the U.S. Constitution. Joining us now to discuss is Marta Belcher, a cryptocurrency and civil liberties attorney. She's written an article on CoinDesk.com as part of CoinDesk's Privacy Week series there. Welcome, Marta. Thanks for coming on. So a lot of times these lengthy bills are approved and signed with a few headline-grabbing line items, but hidden in the fine print are provisions that have gotten little attention and review. So tell us what you found.
Yeah, so there was a lot of talk, during the period of the infrastructure bill about the broker provision. And there was very little talk about another provision which would alter Section 6050I of the tax code. And that provision, I think, is actually in many ways much more problematic than the broker provision from a financial surveillance perspective.
All right. So, and I understand it has a $10,000 reporting requirement, which is required of banks. So this is extending this rule to crypto. And what's the concern in that?
Yeah, so the existing Section 6050I of the tax code basically requires that businesses that receive more than $10,000 in cash have to collect the identity details of the person who's paying in cash and then report that transaction to the government. And in some cases, failure to comply can actually be a felony, punishable by 5 years in prison. And so what happened was the infrastructure bill, now the infrastructure law, expanded 6050I to include anyone who, in the course of doing business, receives over $10,000 in digital assets. Right. And so, as of now, the government collects information from cryptocurrency exchanges and the other institutions that are the on-ramps and the off-ramps where people are buying and selling and exchanging cryptocurrency. But, this new law on its face could impose these reporting requirements on many other participants in the cryptocurrency ecosystem. So you're talking about anyone who, in the course of conducting business, receives more than $10,000 in digital assets, which really could be developers to traders to miners to end users. And so these participants could be required to collect really sensitive identity details of their counterparties and then securely handle that sensitive information and then turn it to the government by default without a warrant or potentially face criminal penalties.
And you say this is a constitutional issue. It violates the Fourth Amendment. Tell me a bit about your thoughts on this.
Yeah, so basically, the Fourth Amendment of the United States Constitution requires that the law enforcement get a warrant supported by probable cause before they conduct a search or a seizure. And yet, under the Bank Secrecy Act and sort of existing financial regulations, the government really engages in mass surveillance of bank customers without a warrant. And so, why is that? How is it that they're able to do that? Well, the answer is something called the third party doctrine. And so that's this idea that if you give your financial data to a third party, you really lose your reasonable expectation of privacy in that data. And that traces back to U.S. v. Miller, which was the Supreme Court decision in the 1970s about the constitutionality of the Bank Secrecy Act. And I believe that the Supreme Court today would actually come to a very different decision and would find that this kind of surveillance that we sort of accept as normal in the financial system is actually unconstitutional and violates the Fourth Amendment.
And do you think that there will actually be a constitutional challenge to this provision then?
I hope so. I hope there will be. And if not this provision, I think there are so many other ways in which the Bank Secrecy Act is being applied today, where it's so much broader than it was applied in the 1970s, right? So when the Bank Secrecy Act was being challenged in the 1970s on constitutional grounds, the way that that was being applied was very narrow compared to today. The financial surveillance today is much, much broader. And I think more importantly, really what has happened since the 1970s is the amount of information you can glean about someone based on their financial transactions is huge compared to what it was in the 1970s. And the Supreme Court has really been recognizing in the last over the last decade that in the digital world, the third-party doctrine really shouldn't apply. And they've been chipping away at the third-party doctrine in a series of really strong pro-privacy decisions. And I think that if they looked at the surveillance in the Bank Secrecy Act today, they would come to a similar decision.